Hello friends, I am Arpit and I am here with today's analysis. Today is 12th of March and we're going to deal with one very important topic which is in news. The topic is the Citizenship Amendment Act. This is in news because the government passed this law in 2019 and have notified the rules to implement it now. This act provides for watered down provisions for citizenship to the people belonging to the non Muslim religion, that is, people from Hindus, Sikhs, Buddhists, Jains, from three Muslim dominated countries, that is, Afghanistan, Pakistan, and Bangladesh, to get citizenship of India. This law, when it was passed, a lot of protests were staged against it. It was considered to be discriminatory in nature as it was targeting one community, one religious community, that is Muslims. But it was passed and now the rules have been notified. However, there have been a litigation in the Supreme Court which the Supreme Court will look into in the time to come against this particular law. So let's get started with this topic, that is the Citizenship Amendment Act. Now, this Citizenship Act was for the very first time passed in the year 1955. Over the years, many amendments have been done in it. 1987, 2004, then finally 2019, there was an amendment done in it. Now, it is basically that 2019 amendment which became controversial. And we need to first understand that why it became controversial. So, it became controversial because it was believed to be discriminatory on the basis of religious lines. And it was against one religious community, that is Muslims. That is what the protesters felt. However, the government has given many clarifications time to time that it was not targeting one religious community, but yes, it was for upholding the overall humanity. Now, we need to understand that why this was, I would say, problematic. Like three countries, Afghanistan, Pakistan, and Bangladesh. These countries are Muslim majority countries and they are not secular, they are Islamic countries. They have declared Islam as their official religion. Now, from these countries, if any religious minority in these countries have been persecuted and they have come to India, religious minorities in these countries are non-Muslims because these are Muslim dominated countries. So non-Muslims like Hindus or Buddhists or Sikhs, like Sikhs from Afghanistan or many Hindus from Pakistan, they have fled and come to India. Now the government will grant them the citizenship and will deny the citizenship to the Muslims from these countries. That is why it is considered to be discriminatory on the lines of religion. And that is why those protests were there. So it led to widespread protest in the winter of 2019-20. It is also under challenge before the Supreme Court. It was challenged in the Supreme Court by Indian Union Muslim League IUML in 2020. Supreme Court is yet to hear on this. Now, what is the law? In December 2019, Parliament passed this. As I already told you, the Parliament passed an amendment to the Citizenship Act 1955 to include a provision for grant of citizenship to migrants belonging to the Hindu, Sikh, Buddhist, Jain, Parsi or Christians. All these are, you can see, non-Muslims. These communities who entered India before December 31, 2014 from Pakistan, Afghanistan or Bangladesh. These three countries are Islamic dominant or I would say Muslim dominant countries. Now in a sense, amendment relaxed the eligibility criteria for certain classes of migrants. These are the certain classes for which the criteria was relaxed. What was the criteria relaxed? Basically, if you get, there are multiple ways of getting citizenship in India. One is citizenship by registration, one is citizenship by naturalization. And if you have to get citizenship by these two methods, then we'll discuss what these two methods are also. Then you have to stay for a considerable amount of time in India. And that time period was watered down. That if the members of these religious communities are coming in India from these three countries, so they will get Indian citizenship, even if they are, the time is generally 7 years or 11 years, in 7 years in case of registration, 11 years or 12 years in case of naturalization. So for them, it was relaxed to 5 years. That even if for 5 years these people have been living in India, then they will be granted citizenship. This is what it was. The bill proposed to amend Citizenship Act 1955 and sought to make foreign illegal migrants of certain religious communities, these certain religious communities from Afghanistan, Bangladesh, and Pakistan, eligible for Indian citizenship with watered down provisions. Now, how can Indian citizenship be acquired? There are basically 5 ways through which Indian citizenship can be acquired. One is by birth. If you are born in India, so you get citizenship by birth. Next is by descent. If one of your parents is an Indian citizen and the other parent is not from, I would say, is not an illegal migrant in India, so in that case, you get the citizenship. Even if you are not born in India, you are born elsewhere, but you have parents, one of the parents who is having the Indian citizenship at the time of your birth, you will get citizenship of India by descent. Then through registration, you have to stay here for 7 years. Then you can apply. By naturalization, extended residence in India, that extended residence is 12 years. 12 years is like the last, that is the 12th year, you have to stay on the trot 12 months. Before that, 11 years on an average, you have to have stayed in India. So in that case, you get, citizenship by naturalization. By incorporation of territory into India, if we incorporate any territory into India, make that territory part of India, then also you will get Indian citizenship. So religious communities which are minorities in Afghanistan, Pakistan, and Bangladesh, like the Sikhs, the Parsis, the Buddhists, the Jains, and all, the Hindus, they will get Indian citizenship. They will not be considered as illegal immigrants in India. And if they have been staying in India for 5 years, forget 7 years, forget 12 years, 5 years, then also they will get Indian citizenship. This was that watered down provision according to the Citizenship Amendment Act. So the new law, however, introduced religion as the sixth criteria to acquire citizenship in India, while excluding Muslims from those 3 countries. So this is that new law. Now what does the law change? The bill proposes that the specified class of illegal migrants, specified class means the Hindus, the Buddhists, the Jains, Parsis, Sikhs, and all, from the 3 countries, that is these 3 countries, will not be treated as illegal migrants, making them eligible for citizenship. All legal proceedings regarding their status as illegal migrants or their citizenship will be closed. If there are any cases filed against them or stating or involving their illegal immigration status, all cases will be closed with the passage of this act. That is why people were celebrating yesterday. The refugee has to fulfill some qualifications. One of the qualifications is that person must have resided in India for at least 11 years of the preceding 14 years. That is when naturalization is into account. 7 years when registration, citizenship by registration is into account. Now for these specified cases of illegal migrants, the number of years of residency has been relaxed to 5 years. That is what I said. Now exceptions in the law. This law was not applicable to the entire country. See, 4 states which are part of the 6th schedule, Assam, Meghalaya, Mizoram, and Tripura, this law is not applicable over there. And this law is not applicable where the inner line permit is required under Bengal Eastern Frontier Regulations 1873. Now what is this inner line permit? There are 4 states in India, the 4 easternmost states, to memorize. 4 easternmost states: Arunachal Pradesh, Mizoram, Manipur, and Nagaland. In these states, if you have to visit, you are a non-resident of these states, you have to take a pass. The pass is simply that kind of pass which you used to have or used to take during COVID lockdowns if you had to go out for a certain purpose. So on that pass it is written that what is the purpose of travel to this particular state and all. And this was introduced by the Britishers back then when the Britishers were here, just to maintain the, I would say, sanctity of the tribal people living over there, just to make sure that people from outside of these states do not come and reside here and dominate over these tribal people. And this is still continuing. So those 4 states where ILP is there, and those 4 states where the 6th schedule of the constitution is applicable. In those states, the Citizenship Amendment Act rules will not apply. What does this mean? This simply means that even if the members of minority community from the 3 countries, Pakistan, Afghanistan and Bangladesh, that is the Hindus, the Parsis, the Sikhs and all, if they come and stay here in these states, the 6 scheduled states and the ILP states, they will be treated as illegal immigrants. So it is like this because there's a lot of insurgency in these states. These states are northeastern states, and people from the countries which I have mentioned, specifically Bangladesh, can enter the northeastern states, get access to easy citizenship and spread problems over here. So it is like this. That is why these states were excluded from the Citizenship Amendment Act. Now who can apply for citizenship in India? Application for the grant of citizenship by registration or naturalization. Registration is that where minimum 7 years of stay is needed. Naturalization is that where 12 years of stay is needed. 11 years on an average, and the 12th year should be on the trot, means you have to stay here for consecutive 12 months in the 12th year. Now you can get access to citizenship of India by registration or naturalization if the person is of Indian origin, the person is married to a citizen of India, the person is a minor child of a person who is a citizen of India, the person's parents are registered as citizens of India, person or either of his parents was a citizen of independent India, the person is registered as an OCI card holder. OCI is Overseas Citizen of India. Now, procedure as per CAA rules. Now, UPSC can be very smart and ask you or give statements like the district authorities are involved in granting citizenship to the people, to the minority communities from Afghanistan, Pakistan or Bangladesh. It can give you these kind of statements. And yes, that is true, because that is mentioned in the procedure as per the new rules which have been notified yesterday by the government. Now, what are the steps involved if anyone wants citizenship of India? Now, an application for registration or naturalization under section 6B shall be submitted by the applicant in electronic form to the empowered committee through district level committee. So there are 2 committees, district level committee and empowered committee. District level committee is the first go-to committee, and if this DLC approves your application, it will go to the EC, and finally when the EC approves it, empowered committee approves it, then only you will be granted the Indian citizenship. Now step 2 is you have to first submit your application in electronic format to the DLC. Now step 2 is the district level committee headed by the designated officer as many shall verify the documents submitted by the applicant along with the application. Now it is the DLC which will scrutinize your documents which you have filed, and if the district level committee finds it suitable, then only those documents are forwarded to the empowered committee. So again I will draw this DLC EC. The designated officer shall administer to the application or applicant the oath of allegiance. Let's suppose I want to have Indian citizenship. I will be the applicant. I will file my application with the district level committee in electronic format. The district level committee, the designated officer in that, will administer me oath of allegiance as specified in the 2nd schedule of the Citizenship Act 1955, and thereafter sign the oath of allegiance and forward the same in electronic form along with confirmation regarding verification of documents to the empowered committee. So oath will be administered to me by the DLC I have to take that oath as per the Citizenship Act. And once I take the oath, then that is forwarded to the empowered committee that oath has been taken by this person. In case an applicant fails to appear in person to subscribe the application and take oath of allegiance, the district level committee shall forward such application to the empowered committee for consideration of refusal. Now, what is this oath? Chalo, ye bhi, you need to understand that oath is an undertaking kind of, that this person, my name is this, I am submitting my documents, I want to be a citizen of India. These documents are not fake, they are true in its proper sense, and I promise to uphold the constitutional principles of the country. I take this oath to become a responsible citizen of the country, and all these kind of provisions are there. It is kind of an undertaking or a declaration which I will be declaring. But if I refuse, and if I'm not there in person present while I'm taking that oath, then the district level committee will send this message to the empowered committee to reject my citizenship. Then again, I will write this. The empowered committee, step 5 is the empowered committee may scrutinize the application for grant of citizenship by registration or naturalization submitted by an applicant under section 6b. EC will examine whatever request the DLC has given it. Then, and ensure that application is complete in all aspects and the applicant satisfied all the conditions laid down in section 6b. So when the EC gets satisfied, then only the application is successful. On being satisfied after making such an inquiry as it considers necessary for ascertaining the suitability of the applicant, that he is a fit and proper person to be registered or naturalized, as the case may be, the empowered committee may grant him the citizenship of India. So this is basically empowered committee is more authoritative than the district level committee. That has to be taken into account, and they will be responsible for granting citizenship to any person through registration or naturalization. Now in the first topic, we saw that when this Citizenship Amendment Act was passed in 2019, it was challenged in the Supreme Court by Indian Union Muslim League. And this challenge, when it was challenged in the Supreme Court, many other people also filed petitions indexed to this particular challenge. So IUML was the first one to challenge it in the Supreme Court. Since then, more than 200 petitions have been filed and tagged with the IUML's challenge. Petitions from Asaduddin Owaisi, Jairam Ramesh Chanithala, Mahua Moitra, and organizations like Assam Pradesh Congress Committee, Assam Gana Parishad, and all these people have challenged, or these organizations have challenged the Citizenship Amendment Act in the Supreme Court. Now, in October 2022, a bench comprising Chief Justice of India, Mr. U. Lalit, and Justice Ravindra Bhatt, Hema Kohli, passed an order stating that the final hearings would begin in December 2022, when Justice U. Lalit will be retiring after that. But since then, no hearing has been there. But if you see the Supreme Court's website, so you will find that this particular case is expected to be heard. Now, why are the petitioners challenging it? There are multiple grounds why the petitioners are challenging it. First ground is that it violates Article 14. Article 14 is right to equality. And this clearly states that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. The petitioners here argue that using the religion as a qualifier for or a filter violates the fundamental right to equality. Why? Because see, you are prioritizing the other religions which are non-Muslims, and you are targeting one religion, that is Islam. That Muslims from these three countries will not be allowed Indian citizenship, and they will be considered as illegal immigrants. Now the court will have to look into whether the special treatment given to the so-called persecuted minorities of those countries, persecuted minorities are non-Muslims in those countries, to whom we are giving citizenship, whom we are not considering illegal immigrants. So the so-called persecuted minorities from the three Muslim majority neighboring countries only is reasonable classification under Article 14. See, Article 14 is not absolute. You can do discrimination or you can violate the principles of equality on certain grounds. But those grounds should be justiciable. Those grounds should be reasonable. There is also this larger issue of whether making religion a ground for eligibility for citizenship violates secularism or not. Because here we are keeping religion at the forefront, whereas in secularism we do not keep religion in the forefront. And is it violating secularism? And if it is, then a basic feature of the constitution is getting violated. So this is what the issue before the court is. Now, Supreme Court, although has not heard about or heard this case, but yes, it has said something about this case. Supreme Court has said that the law has to clear two legal hoops. What are these two legal hoops? First, any differentiation between groups of persons must be founded on an intelligible differentia. Intelligible differentia is a concept in Article 14 of the Indian Constitution which refers to reasonable and logical basis for classifying individuals into distinct groups for the purpose of legislation. You are classifying people. You are not making or putting them at equal status. And this is done for the purpose of legislation. So here you have classified people, Muslims and non-Muslims. Now, what is the logic behind that? And whatever the logic is, the differentia, the reason why you have differentiated them must have rational nexus to the object sought to be achieved by the act. There is some objectives of every law. So you have done this division, Muslims, non-Muslims. This differentia should be attached to or should be, helping you in achieve the objective of the law. It should not be distinct from the objective. It is not like you should have or you have done that differentia just because you wanted to discriminate. Then obviously it will run into litigation and it will not be accepted by the Supreme Court. So it has to be linked to the objective of the law, that differences which you have made in the law or this differential treatment which you are giving to the Muslims and non-Muslims, they should be in line of achieving the objectives of the law. And objectives of the law also should be, humanitarian in nature and they should be just. So if these two hurdles are clear, then this law will not be nullified. If any of these legal hoops are, not cleared, then this law can be nullified by the Supreme Court. Can Supreme Court do that? Yes, it can do that. Very recently, it has cancelled out the electoral bond scheme also. So it has that much powers. Now, the last is CAA and Assam. Now, there is 6A of this Citizenship Act, 1955, which too is under challenge before the Supreme Court. Assam Gana Parishad and all, Assam Pradesh Congress Committee and all, they have challenged the section 6A of the Act. Now, what is section 6A, which was introduced in the Citizenship Act after signing of the Assam Accord? Assam Accords was signed in 1985 between the centre and leaders of Assam movement. Assam movement basically was by the students of the universities in Assam against the outsiders, against the illegal immigrants who had come from the erstwhile East Pakistan, and they came and resided here in Assam and they were demanding Indian citizenship. So this movement was called as the Assam movement. And what was basically the outcome of the Assam movement, or what were the provisions of the Assam movement? Now, in Assam movement, one date was identified, that was January 1, 1966. Now, those who have come before January 1, 1966 will be granted Indian citizenship. The rest who are coming after January 1, 1966 have to be deported. They have to go back. But there are provisions also for regularization of those who arrived in the state after that date and up to March 24, 1971. So, largely the date is January 1, 1966. But yes, in certain special circumstances, those people who have come after January 1, 1966 up till March 24, 1971, they can also be granted Indian citizenship depending on the government's approval. Okay. So this was also the basis of NRC published in 2019. This particular date was that date. Now section 6A of Citizenship Act allows foreign migrants who came to Assam after January 1, 1966 but before March 25, 1971 to seek Indian citizenship. So that date which was very much, I would say, focused upon in the Assam Accords. Now according to the Citizenship Amendment Act, that date has been shifted to March 25, 1971. They can also seek Indian citizenship according to the Citizenship Amendment Act who have come after 1966 till 1971. Now, if this effective date of March 24, 1971 is upheld by the Supreme Court as the cutoff date for entry into the state, the CAA could fall foul of Assam Accords since it creates a different timeline. Assam Accords has mentioned this timeline. In certain special circumstances, up till 24 March 1971 can be permitted. But Citizenship Amendment Act has clearly said that, this should be the date after January 1, 1966 and before March 25, 1971. Anyone who has come into India and belongs to a religious minority from those states or from those countries should be granted Indian citizenship. So there will be a mismatch of dates over here, which should not be done. That is why this particular thing is also there in the Supreme Court. So this is all we need to understand about the Citizenship Amendment Act, the rules notified by the government, and why it ran into controversy. From here, the questions can be picked up, both in prelims as well as mains. And with this, we come to an end of today's session. I will be meeting you tomorrow now with more such informative news pieces. Till then, you guys very well know what to do. Keep studying, keep reading, keep writing, and most importantly, keep revising. Namaste. Jai Hind.